Billy from Occam likes to nitpick, and, well, he misses the forest for the trees. I stated very specifically that unless you're under this specific fact pattern, Florida statutes 930.403 or whatever, 93403 doesn't apply. So you can see why I'm saying this isn't a very broad decision. But he wants to broaden it. Billy from Occam wants to broaden it. And why he wants to broaden it, I don't know. I don't think he read the case, but we'll figure it out. If anyone here wants to save themselves 6 minutes, they're going to read this this huge block of text, or wants to see a published opinion that agrees with Merbeest's, then read the one-paragraph summary of the case on Justia. That's as far as I read before I responded to this, because there's typically no reason to respond to any of these things if they are agreeing with me. Congratulations, here's a wall of text that agrees with me. So I say, yes, save 6 minutes by reading your text wall, okay. And then he says, your ability to comprehend written text is amazing. Or are you suggesting that I wrote the whole paragraph on Justia? No, I'm suggesting that that's a big text wall, and for most auditors, it's going to take them 6 minutes to read through it. And then Marcus says that I won't argue with him on the substance of his comment because it's too difficult for me. And Greenbelt, I think he's trying to make fun of Rietveld. I don't know. Only argues the law with those who are not trained in the law. Well, Billy from Occam isn't trained in the law, so I guess I'm okay to argue with Billy on this one. So we'll go ahead and do it. Thank you for the words of encouragement, Marcus. He says the key point is that a meeting between a citizen and the chief of police is by default a public meeting, so there's no expectation of privacy. Well, that is not the key point. The key point again is, as we saw in the conclusion, that it falls outside of the definition of oral communication. You can also see in the discussion that they discuss oral communications first, and then it says also falls under. So actually the key issue is the oral communication. It doesn't fit into the definition supplied in 934.02 where they describe oral communication. Also the public meeting exception applies. Again in 934.02, uttered at a public meeting. So there's two ways that it fails, and there's also a third. But anyway, blah, blah, blah. So he's wrong there in that the key point, it's not the key point that it happened at a public meeting. The key point is that they were determining a Florida statute. What a Florida statute meant, it is not going to be material for anybody else's statute because it is literally basing itself on the definitions that are supplied in that statute and 934.02, 934.03, etc., blah, blah, blah. And it's also basing itself on various rulings that the Florida legislators, their choice of their reasoning. There is reference to the Florida Supreme Court. Here we go. The Florida Supreme Court interpreted 934.02, etc. I mean, this is 100% Florida. This is what a state court should have done. A state court should have been interpreting the statute. See Florida Statute 934.022, subsection 2, I guess. This is why the decision is a bit less narrow than suggested by Merbeest. No. So, all right. So because there is an exception carved out, it is because there's an exception carved out in 934.02. See, there's an exception carved out in 934.02. If in another state there is a statute identical to 934.03 without the exception carved out in 934.02, then you won't have this decision. And in addition, there is also the fact pattern. Chief Royer invited McDonough. McDonough brought a friend. Chief Royer allowed the friend to come in. There was also another officer there. Chief Royer invited McDonough to a meeting where the public, being McDonough and somebody else who McDonough brought with him, who is also a member of the public, were allowed to attend. The court determined that this was a public meeting. If you roll into a police station, into the lobby, and start filming, and a police officer comes over to you and starts talking to you, there is not a high probability that a court will determine that that is a public meeting. Did you meet? Sure. Was it in public? Sure. But is it a public meeting? No. It has a real meaning. These words, you can't just play semantics on them. So that's why I said specifically that it revolves under this fact pattern and Florida statutes. It's fact pattern and statute intensive. So it's not any meeting between a citizen and an official. That it's under this statute, under these fact patterns. Even when it takes place in the official's private office with no one present, well, you can assume that. It is kind of dicta. The court said that it was a public meeting because McDonough was a member of the public and he was invited there for a meeting, but then it also had the other guy there, and the court said, it's especially a public meeting because this other uninvited member of the public was allowed to be there. And it doesn't necessarily, it's not just because there was a meeting. You could theoretically have a private meeting between a member of the public and a police officer. You could theoretically do it. This case doesn't preclude that. Either needs to be some sign or something else said before it becomes something other than a public meeting. I don't think the case said that it required something else. It just basically assumes it. McDonough was a member of the public who attended the meeting at Chief Roy's invitation. So he was a member of the public who was invited to a meeting. I don't know. The public nature of this meeting came all the more evident when Chief Roy allowed Livingston, a second and uninvited member of the public, to attend. The court found the fact that several people were present at a meeting rendered any subjective expectation of privacy unreasonable. Okay. Here, at least, there were 4 participants present, 2 members of the public and 2 public officials who attended the meeting in the performance of their official duties. Moreover, the topic of their meeting was one of acute public interest, citizens discussing allegations of possible police misconduct with the chief of police. The fact that the conduct of the meeting would likely be subject to public record disclosure is underscored by the fact that Aquino assured McDonough that we have all this recorded, what you stated. So it is a fact-based analysis. You have to have the facts. And had one of these facts been different, who knows? Who knows? Therefore, any statute, he goes too far here, any statute with specific rules or exceptions for public meetings, not only wiretapping laws, could be affected by this decision. And I don't believe that is the case. I don't believe that is the case. They were looking at a specific statute, and they were looking at the Supreme Court's interpretations of it, etc. So I don't necessarily think you can overgeneralize it to anything. And in fact, I don't believe this says that. So this is Billy from Occam's interpretation, and we've already established that because I'm addressing it, he cannot be a legal professional. So obviously take it with a grain of salt. He continues, with that said, the odds of there being any statute other than the wiretapping that would be affected are quite low. I don't know. He just pulled these odds out of his ass. And the decision was only needed because of a rather poorly worded definition section in the Florida statute. No. I don't think that this decision was needed. I think the Court of Appeals should have kicked it over to the state to make a decision on it, to a state court, or they should have sought an opinion from like a Florida Court of Appeals or the Florida Supreme Court to figure out what it meant instead of determining it on their own. But hey, I'm just a family law attorney, so what do I know? He says, so I can't really fault Murby's for saying that this decision will have little effect on anything other than a charge in Florida under 934.03. Well, I know, but you don't understand. It is actually, this case, McDonough is literally narrowed down to 934.03 and its definitions in 934.02. But to make this claim would require a view of the definitions used by every other state in the 11th, which I haven't done, and I doubt that Murby's has done either. That is correct. I have not checked every other state in the 11th to see what their laws are. But again, there are too many factors for it to be, even if a state has identical language in their statute, their legislature may have had different intentions, their Supreme Courts may have had different interpretations, their lower courts may have come to different decisions. If a state court has ruled on a state law, the federal government, in looking at interpretation of the state law, the federal court has to defer to the state court's interpretation. The federal court doesn't have to defer to the state court on the interpretation of the constitutionality of that law, but they do have to defer to the interpretation of a state law by a state court. That's our federalist system. And the odds of any of that happening are ridiculously low because we are a diverse group of states. The odds of other states in the 11th having the exact same wording, the exact same interpretations, the exact same lack of clarification from their lower courts, the exact same historic or legislative history, legislative analysis, legislative intent, even the same societal mores and differences, and again, you'd still have to hit the same kind of fact pattern. You'd have to be invited to a meeting at the police station. You may have to have a friend with you because a different court could look at it and say, well, just one member of the public meeting with the chief of police doesn't make it a public meeting. They're not allowing anybody else to show up. Oh, they're not recording it. There's not going to be a record of it. Then obviously it's a private meeting between the chief of police and a member of the public. You have to remember that there are a lot of meetings between the police and members of the public that aren't public record. Like if they're meeting for bids on something, or if they're, I don't know, there's going to be other meetings between members of the public who are there for like business purposes. Like they go into the chief of police and they want to talk about, I don't know, their own personal issues with a particular officer. Like I have a complaint, I don't know, even a complaint might be public. But anyway, I think you get my point. There can be issues where a member of the public has a private meeting with the chief of police. Oh, here we go. The chief's wife wants to come and talk to him. She schedules a meeting with him. She comes in, she wants to talk about what's going on at the kid's school. Is that a public meeting? He's meeting with a member of the public. His wife isn't a police officer in this example. How about that? Does that work? Yeah, so he goes on to say, your ability to comprehend written text is amazing. I don't see where I had actually tried to comprehend his text. I was responding to his first statement, and I thought it was ridiculous. You'd see how much time we spent so far. I don't have it in front of me, but it's been a while. Or are you suggesting that I just wrote the paragraph on Justia? Nothing in here suggests that I'm saying that he just wrote the paragraph on Justia. I can look at the paragraph on Justia. And this isn't law, by the way. This is somebody's, just like my opinion of the case isn't law. This opinion was written by somebody, probably another first-year family law attorney wrote this, and we don't know how accurate it is or not. So anyway, I think I have adequately addressed Marcus's issue. So thank you, Marcus, for pointing out that I only argue with people who aren't trained in the law. Thanks for watching. And, Billy, thank you for commenting. It keeps it interesting. Have a good day.